I have seen a lot of things in my 38 years on this bench. I have seen men in $1,000 suits lie so smoothly that even their own lawyers believed them. I have seen mothers cry real tears and fake ones, and I have learned to tell the difference. I have seen powerful people walk into my courtroom like they were doing me a personal favor just by showing up. But the morning of October 3rd, 2024, was different. That morning, a 26-year-old woman walked into my courtroom in downtown Chicago wearing a coat that probably cost more than my clerk's monthly salary. She walked in like the floor was lucky to have her shoes on it. She looked around my courtroom, the place where I have spent nearly 4 decades of my life, and the expression on her face said everything. It said, "This place is beneath me. You are beneath me, all of you." Her name was Natalie Voss, daughter of Gerald Voss, founder of Voss Capital Group, a private equity firm with holdings across 11 countries and a net worth that financial magazines estimated somewhere between $4.2 and $4.8 billion. Gerald Voss was the kind of man whose name appeared on hospital wings and university buildings, the kind of man whose birthday parties made the society pages, the kind of man who had spent his entire adult life making sure that his daughter never once felt the weight of a consequence. That morning, that particular job fell to me. And I want to tell you exactly how it happened, every detail, because this story is not really about Natalie Voss and her money. It is about a 44-year-old woman named Carol Reyes who drove a 2009 Honda Civic with a cracked dashboard and showed up to that same courtroom in her uniform from the diner where she worked the breakfast shift. It is about what happened when those two women stood in the same room and the law had to decide who mattered more. Let me take you back to where it started. It was a Thursday evening in late August, around 6:40 p.m. on the corner of North Michigan Avenue and East Ontario Street. If you know Chicago, you know that intersection. It is right in the middle of the Magnificent Mile, where the hotels are glass towers and the shops sell things most people only look at through windows. Carol Reyes had just finished a double shift, 11 hours on her feet, carrying plates, refilling coffee, smiling at people even when her back was screaming at her to stop. She was walking to the bus stop 2 blocks away. She was tired in that bone-deep way that only comes from work that never really ends. She had her purse on one shoulder and a plastic bag on the other, leftovers the kitchen staff was allowed to take home. She was thinking about her son, Marcus, who was 16 and had a math test the next morning that he had been stressing about all week. She was crossing with the light, green pedestrian signal, crosswalk, completely legal. Natalie Voss was driving a white Porsche Cayenne and was running late for a dinner reservation at a restaurant where the waiting list was 6 weeks long and the minimum spend per table was $400. According to the police report filed later that night, she ran the red light at approximately 34 miles per hour and struck Carol Reyes on the passenger side of the vehicle while Carol was still in the crosswalk. Carol went over the hood. She landed on the asphalt on her left side. Her hip took most of the impact. Her left wrist shattered trying to catch her fall. Her head hit the ground, and even though she was conscious when paramedics arrived, she was confused, bleeding from a gash above her ear, and could not remember for a moment where she was going. 3 witnesses at the scene immediately told responding officers that the Porsche had the red light. Security footage from a hotel across the street confirmed it within the hour. The case was not complicated. It was not close. There was no reasonable dispute about what had happened. Natalie Voss, at the scene, did not ask Carol if she was okay. According to 2 of the 3 witnesses, she stood next to her car, looked at Carol on the ground, and said, and I am quoting from the witness statement submitted to the court, "This is such an inconvenience. My lawyers will handle this." Then she made a phone call. Carol spent 4 days in Northwestern Memorial Hospital, fractured pelvis, shattered wrist that required 2 surgeries and 7 screws, a mild concussion that left her with headaches for weeks afterward. The diner held her job for 12 days. After that, they needed someone who could actually carry plates. She lost her job. She had no disability insurance. She had no savings beyond what she kept in a joint account with her sister for emergencies. The medical bills started arriving before she was even fully off the pain medication. The hospital, the surgeon, the anesthesiologist, the physical therapist, each one a separate envelope, a separate number, a separate weight, added to a pile that kept growing while she sat in her sister's apartment because she could not manage the stairs to her own place on a fractured pelvis. She filed a civil complaint against Natalie Voss. That is what brought them both to my courtroom. Now, before I tell you what happened that morning, I want to tell you something about how I see my job, because I think it matters for understanding everything that comes after. I became a judge because my father told me once, when I was about 12 years old, that the courtroom is the only room in America where a poor person and a rich person stand on the exact same floor. He said it like he believed it completely, and I was young enough to believe it with him. I have spent 38 years trying to make that true. Some days are easier than others. Some days you feel it, that balance, that level ground. And some days someone walks in wearing a coat that costs more than a working woman's medical bills and looks around your courtroom like it smells bad. Those days test you. I have learned that being tested is not the problem. The problem is failing the test without even knowing you failed it. Natalie Voss arrived with 3 people. Her personal attorney, a man named Douglas Hale from a firm on Wacker Drive whose hourly rate I later found out was $950, a second attorney who appeared to be junior carrying 2 rolling briefcases, and a woman I initially took for another attorney but later understood was a personal assistant whose sole job that morning seemed to be making sure Natalie was never without her phone or her water bottle. They occupied an entire row. Carol Reyes came alone. She sat down carefully because sitting still hurt her hip on bad days, and that was a bad day. She had brought a folder with her documents organized in plastic sleeves, medical records, bills, a printed copy of the police report, the security footage still, which someone had captured for her. She had done all of this herself, without a lawyer, because she could not afford one and had not yet connected with legal aid services. I noticed all of this before I even called the case. My clerk called it at 9:22 a.m., Reyes versus Voss. Carol stood. Natalie Voss stayed seated for just a moment longer than necessary, not long enough to be held in contempt, but long enough to make a point, and then rose slowly, like she was doing the room a favor. I asked both parties to confirm their identities for the record. Carol said her name clearly, hands clasped in front of her, eyes forward. Natalie Voss looked at me and said her name like it should have been enough. Like saying Natalie Voss in a room should cause a shift in the air pressure. I asked if she was represented by counsel. Douglas Hale stood and introduced himself, and I watched him do the thing expensive lawyers sometimes do in courtrooms like mine. He was polite, professionally courteous, but there was a slight adjustment in his posture that said he was accustomed to larger rooms, federal courtrooms, rooms with better carpet. I have seen that posture before. I am never impressed by it. I asked Carol if she had legal representation. She said no, Your Honor, she did not. She said it simply, without embarrassment, the way someone says a fact. I told her that was fine and that I would make sure she had full opportunity to present her case. I meant it. I asked Carol to begin. She stood up straight and she told her story. She started with where she was going that evening, not because it was legally relevant, but because she needed to start somewhere that felt real to her, and I let her. She talked about the double shift. She talked about the crosswalk. She talked about the light being green. Her voice was steady for most of it, but when she got to the part about waking up on the ground and not knowing where she was, it wavered just slightly. She pushed through it. She submitted her documents, police report, medical records, the security footage still, witness contact information. She explained the job loss. She explained the medical bills, $84,000 and climbing at the time of filing. She explained that she had not been able to return to full work because her wrist had not healed correctly after the second surgery, and she could not carry weight with it the way her job required. She said all of this in about 12 minutes, clearly, honestly, without drama. When she sat down, the courtroom was quiet for a moment. Then Douglas Hale stood up. He was good at his job, I will give him that. He did not attack Carol directly. That would have been a mistake, and he knew it. Instead, he worked around the edges. He questioned the precise timing of the traffic signal. He noted that the security footage still was a single frame without confirmed timestamp metadata. He suggested that Carol may have stepped into the crosswalk before the signal fully changed. He used the word "unfortunately" a lot, in the way lawyers use it when they want to sound sympathetic while arguing that the other person deserves nothing. He submitted a report from an accident reconstruction specialist, a private firm, that raised questions about the point of impact relative to the crosswalk boundary. He said his client accepted that an accident had occurred, but that the question of full liability was more complex than the plaintiff was presenting. It was competent legal work. It was also, in my assessment, the construction of a fog machine pointed directly at a clear set of facts. I let him finish. Then I looked at Natalie Voss and I asked her directly if she wanted to make a statement. Douglas Hale immediately said, "Your Honor, I'll be speaking on behalf of—" I said, "Mr. Hale, I am asking your client." There was a pause. Natalie Voss looked at her lawyer. He gave her a very small, almost invisible shake of his head. She looked back at me, and then she did something I did not expect. She spoke. "I just think," she said, and her voice had the particular tone of someone who has never been told their opinion was not needed, "that this whole thing is being blown way out of proportion. Accidents happen. I've cooperated fully. My family has offered a settlement." I said, "A settlement offer was rejected. Is that correct?" She blinked. "Yes, but what was the amount of the offer?" Douglas Hale stepped forward. "Your Honor, the terms of settlement discussions?" "The offer was $11,000, Carol said quietly from her seat. The room shifted. $11,000. Against $84,000 in medical bills, against a lost job, against 2 surgeries and months of physical therapy, against a fractured pelvis and 7 screws in a wrist, $11,000. Natalie Voss did not look embarrassed. She looked annoyed at being interrupted. She continued, "My attorneys advised that amount based on comparative—" I held up my hand. "Ms. Voss," I said, "I want to make sure I understand your position. You are saying that the accident is being blown out of proportion?" "I'm saying that accidents happen and—" "Ms. Voss, I have the police report in front of me. I have 3 witness statements. I have security camera documentation. I have medical records. None of what I have in front of me suggests an accident in the sense of something that was no one's fault. What I have in front of me suggests that you drove through a red light and struck a pedestrian who was legally crossing the street." She straightened. "I had a green light. 3 witnesses disagree with you. Witnesses make mistakes. The security camera does not." She looked at me then with an expression I have seen before on faces of people who have never truly been challenged by anyone. It was not quite anger. It was something older and stranger than anger. It was disbelief, pure, clean disbelief that this was happening to her, that I was speaking to her this way, that the room was not adjusting itself to her comfort. And then she said it. She looked directly at me and she said, "Do you know who my father is?" The courtroom went completely still. I mean that literally, the kind of still where you become aware of the ventilation system humming, where you can hear the person 2 rows back shift in their seat. My clerk, Patricia, who has worked with me for 19 years and has seen more courtroom moments than most people ever will, told me afterward that she had to look down at her desk because she did not want her expression to influence anything. I looked at Natalie Voss for a long moment, then I said, "I know exactly who your father is, and in this courtroom it does not matter." She made a sound, not quite a laugh, something shorter than a laugh but carrying the same disbelief. And then she said something that I have thought about many times since that day. She said, "You're just a traffic judge. You're a nobody with a gavel." I want to tell you what happened inside me when she said that, because there is a version of this story where I get angry, where the emotion of that moment takes over and I say something sharp and satisfying and the crowd cheers and that is the end of it. I have seen that version of events play out in courtrooms before. Judges are human. We get pushed. We push back. Sometimes it looks like justice and sometimes it just looks like 2 people fighting, one of whom happens to be wearing a robe. That is not what I wanted that morning. What I felt, if I am being fully honest, was not anger. It was something quieter and colder. It was clarity, the kind of clarity that comes when someone finally says out loud the thing they have been thinking the entire time, and the saying of it removes every last question about where you stand and what needs to happen next. She had just told me, in front of witnesses, in an open court on the record, that she believed she was above this process, above this room, above me, and by extension, above Carol Reyes, who was sitting 5 feet away with 7 screws in her wrist and $84,000 in medical debt and nowhere to be that morning except here. I folded my hands on the desk in front of me. I said, "Ms. Voss, I am going to ask you to sit down." She stared at me. "Please sit down," I said again, calm, even, completely serious. She sat. I could see Douglas Hale exhale slowly next to her, like a man who had just watched someone else nearly step in front of a bus. I said, "I want to address what you just said because I think it deserves a response and because I want everything I say in the next few minutes to be on the record." The room was still completely quiet. "You asked me if I know who your father is," I said. "The answer is yes. Gerald Voss, Voss Capital Group. I have read about him. Most people in this city have. He has done some genuinely significant things with his money and his influence, and I do not say that sarcastically. I mean it. But here is what I need you to understand about this room. Your father is not here. His name is not on the case file. His money is not a party to this proceeding. You are, just you. And in this courtroom, you are not Gerald Voss's daughter. You are a defendant in a civil case with a significant body of evidence against you. You called me a nobody with a gavel. I paused there. I have been doing this job for 38 years. I have presided over thousands of cases. I have seen people walk into this room terrified, and I have tried to make sure they felt that the process was fair. I have seen people walk in arrogant, and I have tried to make sure they understood that arrogance is not a legal argument. I wear this robe because this community trusted me with a responsibility, not because I am important, because the work is important. And the work right now is this. A woman named Carol Reyes was struck by your vehicle while she was legally crossing the street. She sustained serious injuries. She lost her job. She has incurred significant medical debt. And the settlement your representatives offered her, $11,000, does not begin to address the actual harm caused. You are not in trouble today because of who your father is or is not. You are in this courtroom because on August 29th, at approximately 6:40 in the evening, your choices had serious consequences for another human being, and that human being deserves to have those consequences acknowledged honestly. I let that sit for a moment. Then I looked at the documents in front of me. What followed was the legal portion of the ruling, and I want to walk you through it carefully because I think it matters. I think the details matter. I think the specificity of what justice looks like is important because justice is not a feeling. It is not a speech. It is a set of specific decisions made carefully on the basis of evidence. The speech is just the frame. The ruling is the actual thing. The evidence was clear. 3 independent witnesses, security camera documentation, a police report written at the scene. The accident reconstruction report submitted by the defense raised questions that were, in my assessment, not supported by the actual evidence on record. A single-frame security still, contrary to what the defense argued, was fully sufficient when combined with 3 corroborating witness statements. The defense's claim that Carol may have entered the crosswalk before the signal changed was contradicted by the witness testimony and not supported by the camera still, which showed her clearly within the marked crosswalk boundaries. I found in favor of Carol Reyes on the question of liability, fully. No comparative negligence assigned to the plaintiff. On damages, I reviewed the submitted medical bills, the physical therapy records, the documentation of lost employment, and the projected impact of the wrist injury on Carol's ability to return to her previous occupation. I also took note of the ongoing nature of her recovery at the time of the filing. I awarded Carol Reyes $124,000. That number covered the full medical expenses to date, projected physical therapy costs, lost wages for the period of documented inability to work, and a reasonable amount for pain and suffering that I kept conservative, because I am always conservative on pain and suffering, not because I do not believe it exists, but because I want my awards to survive any appeal without question. $124,000, not $11,000, more than 11 times what had been offered to make this woman go away quietly. When I announced the number, Natalie Voss made a sound, a kind of short exhale, like the number was almost funny to her, like $124,000 was a minor irritation. And maybe for her, it was. Maybe for someone whose father was worth $4 billion, $124,000 was genuinely not a significant amount of money in any practical sense. But that was not the point. The point was Carol Reyes, who pressed her hand to her mouth when I said the number and looked at the ceiling for a moment, the way people do when they are trying not to cry in public. The point was the folder on her table, the one she had organized herself in plastic sleeves because she could not afford a lawyer. The point was the $84,000 that had been sitting on her, pressing down on her for months. The point was the 7 screws in her wrist. $124,000 would not undo any of that. No amount of money fully undoes physical injury and lost time and the particular fear that comes from not knowing how you will pay for the care your body needs. But it was honest, it was proportionate, it was what the evidence supported, and it was real. Douglas Hale immediately indicated that they would be filing for reconsideration. That was his right. He was professional about it. He did not make a scene. Natalie Voss was less professional. As she stood to leave, she looked at Carol for a moment, and then she said, not loudly but clearly enough to be heard, "Enjoy it," like it was a consolation prize, like Carol had won a game at a carnival. I said, "Ms. Voss." She stopped. "What you just said to Ms. Reyes will be noted in the record as well. I want you to understand something before you leave this room. The resentment you feel right now, that sense that something unfair has happened to you today, I want you to hold on to that feeling, because that is a very small version of what Ms. Reyes has been living with since August 29th. That discomfort you feel, that is what justice feels like from the losing side. It is supposed to feel like something. That is how you know it meant something." She left. The room exhaled. After the courtroom cleared, I sat in my chambers for a while before my next case. That is something I do not always do. I usually move quickly through the docket. There is always another case, always another set of facts waiting for attention, but sometimes a morning asks you to sit with it for a few minutes before you move on, and that was one of those mornings. I thought about what Natalie Voss had said. "You're a nobody with a gavel." I have turned that phrase over many times since then, not because it hurt me. I want to be clear that it did not in any lasting way, but because of what it revealed, because that belief that some people are somebodies and others are nobodies is the exact belief that the courtroom exists to correct. It is the belief that says the rules are for other people, that accountability is a thing that happens to lesser people, that money and name and connection are a kind of legal armor. They are not, or at least they should not be. And in my courtroom on that day, they were not. That is the job. I found out later through my clerk, who follows these things more closely than I do, that the Voss family's legal team did file for reconsideration. They submitted a detailed brief arguing several procedural points. It was reviewed. It was denied. The award stood. I also found out, about 3 months after the ruling, that Carol Reyes had used part of the settlement to complete a medical billing advocate certification course she had started online during her recovery. She had taken the course in the evenings, on her phone, while her hip was healing, because she needed something to do that felt like moving forward. With the settlement secured and her immediate debts addressed, she was building toward a new direction. My clerk told me this and then said, "I thought you'd want to know." She was right. I did want to know. There is something I want to say directly before I close this story, because I think it is easy for a case like this to become a simple story about a villain and a hero. Rich girl bad, working woman good, judge swoops in, justice is served, everyone learns a lesson. Real life is not quite that clean. Natalie Voss is 26 years old. She was raised in an environment where consequences were managed, where problems were solved by phone calls to the right people, where the word no was rare and the word sorry was even rarer. That environment produced the woman who stood in my courtroom that morning. I am not excusing her. Her behavior was inexcusable. The way she spoke about Carol Reyes, the settlement offer, the comment on her way out, none of it was acceptable, and I said so. But I am also aware that people who are never taught accountability do not automatically know how to exercise it. The failure is theirs, yes, and it is also the failure of every person around them who made it easier to avoid accountability than to face it. I do not know if Natalie Voss left that courtroom changed. I genuinely do not know. I hope she thought about it. I hope the discomfort of that morning stayed with her long enough to teach her something. But I cannot control that part. No judge can. We can make the ruling. We cannot make the lesson land. What I can control is making sure the ruling is honest, making sure the room is level, making sure that Carol Reyes and every Carol Reyes who walks through those doors with a plastic-sleeved folder and no attorney and 7 screws in her wrist gets the same floor to stand on as everyone else. That is the job. That is the whole job. The morning after that case, I came in at 8:15, the way I always do. Patricia had the coffee going and the files on my desk. There were 14 cases on the docket: parking violations, a fender bender dispute, a noise complaint that had somehow escalated into a civil filing. The ordinary work of an ordinary courtroom in an ordinary city. I sat down with my coffee, I read through the files, and then I put on my robe and walked through the door to the courtroom the same way I have walked through it for 38 years, because that is what this job looks like from the inside. Not speeches, not viral moments, not the satisfaction of watching arrogance collapse in real time, though I will admit that particular satisfaction has its own weight. It looks like showing up, case after case, morning after morning, file after file. It looks like reading carefully and listening harder. It looks like treating the person with the cracked dashboard Honda and the plastic-sleeved folder with exactly the same attention and seriousness you give the person with the $9.50 an hour lawyer and the designer coat every single time. That is what my father meant when he said the courtroom is the only room where everyone stands on the same floor. He was telling me what was possible. He was also telling me that possibility is not automatic. Somebody has to keep the floor level. That is the job. That will always be the job.